Hi everyone. In this class, I want to discuss with you business law related topic. Here I am going to give lecture as well as notes for the students on topic. Let us go and discuss what actually is a topic. Our topic is discharge of a contract. You already know what is contract. I discussed with you in previous classes. Contract means it is an agreement and enforceability by law. So here the contract is going to be discharged. So what is discharge of contract? Discharge of contract means putting the contract at end. Okay, so here we are the parties are going to terminate the contract, then we can call it as discharge of a contract. Termination of the contract is known as discharge of contract. So here the agreement whatever they made, they are going to make it null now, so they are not going to perform it. Okay, then we can say that the contract is discharged. So discharge of contract is nothing but putting the contract to an end, as well as it is a termination of the contract and the parties are not going to perform the contract and they are going to end it. Okay, so ending point of the contract is known as discharge of contract. Here the contract whatever they created, they are going to put end for that. Okay, then we can call it as discharge of a contract. So let us discuss one example here. Here I'll read the example. First look into that, then I will explain. So here you can watch that example also I gave. A says to B that I promise to sell my bike to you for rupees 50,000. So here A is saying to B that A wants to sell his bike to B for 50,000 rupees. And what B said, B replied that I promise to pay rupees 50,000. So B also said that okay, I will pay 50,000 to you. Okay, A is ready to sell his bike and B is ready to pay money. A relationship has been created between these two parties. Whenever they both are agreeing for that, offer is there, acceptance is there, then we can call it as an agreement. So whenever any agreement is there, okay, then if that is enforceable by law, we can call it as a contract. But here what happened, when this contractual relationship get cancelled or get terminated, then we will call it as a discharge of a contract. Here the parties are not going to perform. Okay, whatever they have to perform, if they don't perform that, any one party or due to any reason, if they are not going to perform anything, then we can call it as a discharge of a contract. Okay, hope this is clear what is discharge of contract. Let us move and discuss what are various modes under which the contract is going to be discharged. Okay, so there are 6 modes are there through which we can discharge the contract. So what are those? First one is discharge by agreement. So second one, discharge by operation of law. Third one, discharge by breach. Fourth one, discharge by performance. Fifth one, discharge by impossibility. Sixth one, discharge by lapse of time. So in these 6 ways, the contract may be discharged. Let us discuss what are all those clearly. Let us discuss the first one, that is discharge by agreement. So actually contract is created by 2 parties and that contract actually they enter into the contract by their mutual agreement. They agree for that and they enter into the contract. Okay, automatically the rights and obligations are created by the agreement in between the parties. Okay, whenever both are agreeing to do anything, then rights will be there for one party and another party have to perform something. So here rights as well as obligations of 2 parties are created by that agreement. Okay, so here these rights and obligations will be discharged whenever actually they are not going to do anything whatever they agreed upon. Okay, whatever they agreed upon, and whatever are the terms and conditions, what actually the rights and obligations of the parties, if they are not going to perform that, then the contract is going to come to an end. Okay, the discharge by agreement will take place. So the terms and conditions, whatever they actually agreed upon while making the agreement, or whatever rights and obligations are formed at the time of agreement, if they are not able to perform that, then the contract gets discharged. Okay, so under this discharge by agreement, again, in what way the discharge by agreement comes to an end? Let us see. There are different ways under this again: novation, alteration, rescission, remission, waiver, accord and satisfaction. Okay, so these are different ways under which actually the discharge of contract takes place by agreement. Okay, this comes under discharge by agreement. So let us discuss one by one now. First one is novation. Novation means actually one contract is formed. Okay, so in the place of that old contract, if any new contract is formed again. So in the place of old contract, if any new contract is replaced, okay, they are replacing old contract with the new one. Okay, then we can say that novation has taken place, and we can call it as novation, and we can say that the old contract will come to an end whenever new contract is replaced with. Okay, so in the place of old contract, they are actually performing the new contract, they are forming the new contract. Okay, instead of completing the old contract, they are making another new contract in the place of old contract, and old contract is not going to be performed. Then we can say that old contract came to an end. So this old contract is discharged by novation. Okay, so novation takes place. Actually, novation may occur in two ways again: when new party is substituted for the old one. So actually in the old contract some parties will be there, but new parties are going to perform that instead of old parties. Then we can say that there is a novation in the contract. Okay, in the novation in the discharge of contract. And sometimes in the place of old contract, new contract will be substituted. Okay, so here in the place of old one, new will be substituted or new contract is formed. That time also we can say that there is a novation. Hope this is clear for everyone. Okay, when novation takes place, whenever any new contract is formed in the place of old one. Okay, old one comes to an end, then we can say that there is a novation. And when old one comes to an end, when old parties are not doing that contract, and in the place of old one, new other parties are going to perform, that time novation takes place. And in the place of old contract, they are going to perform new contract, they are forming the new contract, that time also novation takes place. Okay, so here there is an example, you can see that. I will read the example, then I will explain. A owes money to B under a contract. Here A has to pay money to B. A owes money to B means A has to pay money to B under one contract, and it is agreed, that is agreed, not agreed, 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 agreed between A, B and C that B shall henceforth accept C as his debtor instead of A. So here A actually has to pay money to B, but what is happening here? Instead of A, C is going to A owes money to B under one contract. Okay, so here it is agreed between A, B and C. Three parties are agreeing that B shall henceforth accept C as his debtor. So B is going to collect money from C instead of A. Actually A has to pay money to B, but there is an agreement again in between A, B and C. What happened? C is coming forward and saying that instead of A, I will pay money to B. Okay, C is going to pay money to B. So here B is accepting C as his debtor instead of A. So instead of collecting money from A, what B is doing? B is going to collect money from C. Okay, here new C. Now what is a new contract here in between C and B. Okay, in the old contract A and B were there, but in new contract C and B are there. Parties are changing. Okay, so we can say that this is an example for novation. Here, first of all, listen carefully. A has to pay money to B. A owes money to B, but later on there is an agreement. Okay, A, B and C in between three parties. And what happened here? C is saying that instead of A, I will pay money to B. So B is going to collect money from C now in the new contract. So new contract is in between B and C. Old contract was in between A and B. Okay, in the place of old one, new contract is formed. But in the new contract, parties are going to change. One party. Instead of A, C is going to pay money. Okay, so this is what actually, this is a novation. Discharge of contract by novation. Let us go and discuss next one. So the next one is alteration. Alteration means making some changes, ma. Okay, so here what is alteration? Whenever any changes are made to the terms and conditions of the contract. Okay, so then we can call it as alteration. So whenever already parties are there, they agreed upon something, there is one contract, but later on they want to alter the contract. They want to make some changes to the contract. When it is valid, when alteration is valid, whenever two parties are giving their consent for the alteration, then only it is valid. Okay, two parties should accept for alteration of the terms and conditions of the contract. Then we can call it as valid contract, valid alteration. Okay, alteration, in case of alteration also we can say that it is discharged by alteration. And when alteration takes place, when both the parties to the contract accepts or gives consent for the alteration. Okay, let us discuss next one, rescission. Rescission, actually here what is rescission? Okay, let us discuss that. So first I will read that point, listen carefully. If the parties to the contract agree to rescind it, rescind means cancelling it. Okay, so two parties are there. Two parties, first they formed one contract. They entered into one contract. Now they both want to rescind it. Means they want to cancel it. The original contract need not be performed. This is discharged by rescission, which requires mutual consent and consideration. Okay, rescission means cancellation of the contract. Hope this is clear. This sentence gives you complete meaning of the rescission. Rescission means cancellation of the contract. But that cancellation of the contract actually will be done only if both the parties of the contract gives their consent. Okay, so they want, both the parties are agreeing that they want to end up that contract. They don't want to continue that. Then original contract comes to an end because they need not to perform it. Both the parties should agree. Whatever parties, two parties are there in the contract, they must give their consent for not continuing the contract. They are going to stop it. Okay, they are not going to perform it. So we can say that that is rescission, discharge by rescission. Okay, so rescission means cancellation of the contract. Hope this is clear. So here, when actually a contract may be rescinded. So in following ways, actually they have given three ways here. Under these three cases, the parties are going to rescind the contract. They are going to cancel it. Okay, so first one is by mutual consent. Both the parties are giving their acceptance that they are going to cancel that. Okay, by mutual consent, both the parties are agreeing and that they are going for discharge of contract. They are going to cancel the contract. Next one is by the aggrieved party. So here one party is not going to perform it and he is making the contract to come an end. Next, third one is by the party whose consent is not free. If any party actually, first of all, at the time of making the contract, if the party did not give consent freely, he did not agree freely, okay, there was some force on him to enter into the contract, then we can say that consent is not free. So that time, later on, he can rescind the contract, okay, by saying that he did not give his consent freely. So under these 3 points, okay, under these 3 cases, they are going to rescind the contract. We can call it as rescission. Hope this is clear. Let us move to next point. Next one is remission. Okay, next one is remission. Remission means actually there are two parties, they agreed upon something. Okay, so one party is accepting that he is going to receive less amount from the other party. Okay, or he is accepting, one party is accepting that the other party can perform less degree of performance. They can perform actually the first party is reducing the work of the other party. Okay, the other party, whoever have to perform, he is going to perform lesser degree of performance. Here then we can call it as remission. Remission means lesser amount will be paid by one party, or lesser degree of performance is going to be done by one party. Okay, then we will call it as remission. Clear? So here one party is going to, suppose for example A and B, two parties are there. So A has to pay 50,000 to B, but instead of paying 50,000, A is saying that you can pay 49,000. So less amount he is paying. We can say that it is a remission. And lesser degree of performance. So one party is going to perform less instead of performing what he has to do. Okay, then also we can say that it is remission. Next one is waiver. Waiver means actually here a party to the contract, one party to the contract, actually he is going to waive his rights. Okay, he is going to waive his rights. So what is that? Let me read the point and let me discuss that. It means the abandonment of right which a person is entitled to do. A party to the contract may waive his rights under the contract whereupon the other party is released from his obligations to constitute a waiver. Neither an agreement nor consideration is necessary. So here, what is waiver? Actually, first of all, both the parties entered into contract. There are rights and obligations for both the parties. But later on, what actually they are doing? Parties are the party who actually is giving contract. He actually is forbidding that. Okay, so he is saying that okay, you need not to do this, and I am going to I'm not going to perform one party is saying that I am not going to perform this. Okay, otherwise other party is saying that I want to take the contract back. Okay, I'm going to forbid it. So then we can say that there is a waiver of contract. So let me discuss one example so that you will understand. A promises to paint a picture for B. So here A is promising, and what he is saying to B, that he is going to paint a picture for B. Okay, so B later on forbids him to do so. What B is saying, you need not to draw a picture for me. Okay, so here B is forbidding. Then A is not required to draw picture. No, A is not going to fulfill his promise. Okay, then we can say that the contract is discharged by waiver, because one party is forbidding the other party to do that. Okay, one party is saying that don't do that, the other party need not to perform. No, then we can say that it is a discharge by waiver. Hope this is clear for everyone. Let us discuss next one, that is accord and satisfaction. So here actually accord means the promise to accept less than what is due under the old contract. Okay, so here in the old contract, if suppose one party has to pay some amount, but here he is promising that he will pay less than what he has to pay. Okay, we can call it as accord and satisfaction. Okay, so in this way the contract is going to get discharged. So let us take one example here. A owes 1,000 rupees to B, and B is accepting that and agreeing to accept that 750 in full satisfaction. Okay, here there is a settlement in between A and B. Actually A has to pay to B 1000 rupees, and B is agreeing that okay, you can pay 750 rupees, and he is satisfying for that. Okay, and here the agreement is just to pay 750, that is an occurred here. Actual payment is what, 1000 rupees. Okay, in the place of actual payment there is a satisfaction with 750 rupees only. Okay, then we can call it as occurred. In this way also contract gets discharged. Let us discuss next one. Next one is, actually under first one we finished everything. Okay, discharged by agreement. We have A to F points, all points we discussed. Now this is a second one, discharge by operation of law. So here law is coming into picture. So law is, because of rules and regulations of law, the contract is going to get discharged. So what actually are those? Let us discuss all that. First one is insolvency. Insolvency means one person, if he is not having paying capacity, then we can call it as he is having insolvency position. We can say that he is an insolvent. Okay, so whenever any person becomes insolvent, then rights and liabilities of that insolvent will be actually there will be some exceptions for that. Okay, because he is not having paying capacity, he became an insolvent, so all obligations and his liabilities, rights, everything will be transferred to officer. Okay, because the court will appoint the officer whenever any person becomes insolvent and he is having some obligations, he's having liabilities, he has to perform something. Okay, and his his liabilities and his assets, everything should be distributed for payment of liabilities. His amount, his cash, whatever he has should be distributed for the payment of liabilities. Then that time court will appoint one officer, and all the obligations and rights of that particular insolvency will be transferred to an officer. Okay, so we can call him as an official assignee, and we can also call him as an official receiver. So he will act as an agent. Actually he is not an agent, he is an officer appointed by the court, but he will act everything on behalf of the insolvent. So the person who became insolvent, he is not going to do anything now. Whatever rights and obligations are there on part of insolvent, everything will be transferred to official receiver. Court will appoint him. Okay, court appoints the official receiver, and he is going to do everything on behalf of that insolvent person. So here insolvent party, rights and everything, okay, rights, obligations, everything came to an end. So this is discharge is done by operation of law. Next one is merger. So here under this merger, actually what is it actually? Let me read that, you will understand in a better way, then I will explain. It occurs, merger occurs when there is acceptance of a higher security in the place of the lower. Okay, so here they are accepting higher security in the place of lower one. It is an operation of law which extinguishes coinciding with another and greater right in the same person. Okay, here what happened, in the place of lower one they are accepting higher one. Okay, then we can say that that is a merger, and this is done only by the law. Okay, so here let me take an example. A holds certain property under a lease. Okay, so A is having some property, and that property is not owned by him, he has taken on lease. Lease means owner is other person, he has right to use that. A is taking on lease basis, so for the lease period he can use that property. Okay, so he will pay rent for that, and that property he has. What property? Lease property. Subsequently he buys the property, later on he purchased that. Okay, same property he purchased, the property whatever he has taken on lease basis, he purchased it now. His rights as a lessee is merged into his right of ownership now acquired. So actually whenever he had taken the property on lease basis, that time that was a lease contract in between those two parties. Okay, so A is not owner that time, but later on same property was purchased by A. Then A is not lessee now. Okay, in the previous agreement, lessor is the owner of the property, lessee is A. Okay, but here now he is not a lessee. Okay, why? Because he purchased same property, he became owner of that. So lessee rights are merged into the ownership. Okay, now he is not a lessee, so the rights whatever he had as a lessee, all are mixed. Okay, into the rights of what? Ownership, because he acquired the property, same property he purchased. Now he became owner in the place of lessee. Okay, this is called merger. Whenever any merger takes place, merging means mixing. Okay, otherwise we can say that if two are clubbed together, then we can say that it is a merger. Okay, here lessee became owner. Okay, so lessee and owner are one and the same now. Okay, so that is why we can call it as merger. So let us discuss. Here what is happening in case of merger? Old lease agreement is coming to an end. That is a point that we have to discuss here. Okay, so lease agreement, lease contract is discharged. So that contract has come to an end because of merger, because A purchased the same property, so he is no more lessee now because he became owner. So old agreement, old contract was come to an end. Okay, because of merger. So let us discuss next one. Next point is alteration. So alteration means what? Making some changes to the contract. Okay, so if any person makes the changes, there are two parties in the contract. If one person makes any changes in the contract, then that should be done with the help of the consent of the other party. If there is no consent of the other party and without consent of the other party, okay, if only one party is making some changes to the written contract, then other party can go for discharge of the contract, because he is not accepting for the changes and some material facts. Okay, some important matters in the contract are changed without his acceptance by the other party. Other party is altering without acceptance of second party. Then second party can go for discharge of contract, because alterations are done by only one party and second party did not accept that. Okay, so next one is death. Whenever two parties are there in the contract, if one party promise to do something, okay, other party also accept, but one party died, the one who actually has to perform anything, that person actually died. Due to death of that person, the contract comes to an end. Okay, because whenever that contract should be done only by the person only, his personal qualification and his presence is required to perform the contract, but he is no more now. Okay, because he died, then that contract comes to an end only. Okay, discharge of contract by death. Hope this is clear. Let us move to next one. So next one is, this is third point. Okay, third mode of discharge by discharge of contract. Third. Okay, this is various mode we discussed in the beginning. Okay, so this is the third one, discharge by breach. So here, parties to the contract, both the parties have to do something or have to perform something. Some obligations will be there to perform. But if any one party is failing to perform his obligation, okay, one party is not able to perform, then automatically there is a breach of contract, because one party is failing to do that, or one party is not able to perform the contract, then we can say that there is a breach of contract. Okay, whenever one party is able to perform but other party is not able to perform or failing to perform it, okay, whenever any other party is failing to perform the contract, then we can say that the one who actually is failing to perform the contract is breaching the contract. Okay, so in case of breach of contract also, contract gets discharged, contract will come to an end because of breach also. There are two breach, actual breach of contract as well as anticipatory breach. So what are those? Actual breach actually takes place when performance is actually due. One party have to perform that, but is not performing, then actual breach takes place. And second one is when actually performing the contract. So actually the thing what actually has to perform, he did not perform, he has to perform it. Okay, then also we can call it as actual breach. And what is anticipatory breach now? Anticipatory breach means here one party is refusing, okay, to do that. So if one party is refusing or saying that I don't want to do that, okay, then a contract comes to an end only. Because whenever any one party is failing or not able to do or not able to perform the contract or not interested to perform, okay, then definitely contract comes to an end. Here one party is saying that he is not going to perform, he is refusing to perform the contract, then we can say that it is an anticipatory breach of contract. Okay, so let us go to next one. This is fourth mode of discharge of contract, discharge by performance. Here discharge by performance means what? Performance of contract is most usual way of discharge of contract. So actually what is this? If any person in the contract, there are two parties in the contract, no? Okay, so if they perform the contract, then automatically contract comes to an end. One party whatever he has to perform, he performed. The other party whatever they have to perform, performed. So both completed the contract, both finished their obligations, okay, both performed their performances, then contract automatically comes to an end only. Okay, contract is no more because both completed their obligations, both finished their performances, automatically contract comes to an end. For example, A is ready to sell his property to B for 1 lakh rupee. So B also is ready to pay 1 lakh. So he paid. Okay, the contract finished with the performance of two parties obligations. So we can say that it is a discharge by performance. Okay, so because nothing is left to do there. Okay, everything is performed. So if once the contract obligations are performed, automatically contract comes to an end. So next one is fifth one, discharge by impossibility of performance. Here actually if there is some impossibility to perform the contract for any party, then automatically contract comes to an end. Okay, so actually at the time of making the contract it was good and both the parties are actually are going to perform it and everything was possible for them. But later on, after passing some days, due to some factors, they are unable to perform that. Any one party, okay, if any one party or both are unable to perform that because it is impossible for them to perform the contract. Okay, it is impossible for them to perform whatever they have to do for the accomplishment of the contract, then contract comes to an end. Why? Because there is impossibility of performance, so the contract will come to an end. We can call it as discharge by impossibility of performance. So when actually discharge by impossibility of performance takes place? First one, destruction of the subject matter. So actually the contract is made on subject matter. There is something main matter of the contract that was destroyed. Okay, suppose A is A is entering into an agreement to B that he wants to sell his building. Okay, building is a subject matter here. Otherwise A wants to sell his car is a subject matter. Okay, if car or building destroyed, there is destruction of the subject matter. Subject matter is no more, it is not there. So how can A sell either building or car to B? Not possible, no. So contract comes to an end. Okay, second one is death or personal incapacity. If any one party died, it is impossible for them to perform. How can they perform? After their death they can't perform. Okay, so or personal incapacity means in case of insolvencies like that, they will not be able to perform that, then also contract comes to an end. Next one is change of law. If any rules and regulations are changed, then they have to follow that. But at the time of making the contract, law is favorable to them to perform the contract, but later on some laws are changed. Okay, so they are unable to perform that after changes made to the law, then automatically discharge takes place because there is impossibility of performance. And next one is non-existence or, that is OR, that is OR, non-existence or ORR, non-occurring of a particular state of things. Actually the contract on which they made, they are not existing now, then automatically contract comes to an end. Okay, so next, declaration of war. Whenever any war is declared by two countries and contract is in between parties of two countries, automatically contract comes to an end because they can't perform the contract whenever any war is declared by countries. So these are the different factors that affects the impossibility of performance, so that contract comes to an end. Let us go to next one. This is the last one, discharge by lapse of time. So here time period is very important. Okay, so if any time period is mentioned or specified in the contract and that time period has lapsed, automatically contract comes to an end. Okay, here promisor, promisee, two parties are there in the contract, and one person is mentioning some specified period in the contract. Within that, the other party has to perform the contract, but that specified period lapsed, automatically the contract comes to an end, even there is a performance of obligations or not. Okay, because time period expired, that is why the contract comes to an end. There is a discharge of contract by lapse of time. So this is about discharge of contract, different modes under which one contract gets discharged. Hope this is clear for everyone. If you understand the class, like the video, share the video, subscribe the channel. Thank you.